A three-judge panel from the Fifth Circuit U.S. Court of Appeals this afternoon upheld part of a decision that rolled back some access to the abortion pill mifepristone. However, the drug's going to remain on the market for now, thanks to a Supreme Court ruling earlier this year, allowing it to remain available as these cases make their way through the appeals process, which means even this ruling doesn't end things. If you're confused, that's why I have our senior legal correspondent, Laura Jarrett, here. So, Laura, it's a little bit confusing, but sort of walk us through what happened today and why it kind of has zero impact.
So the upshot is that nothing changes for now. If you still want to get access to mifepristone, it is as if nothing happened. And as you said, Chuck, that's because of the Supreme Court decision. What this does, though, is it tees up the Supreme Court to wade back into this issue, and it could happen pretty quickly. Because what the Fifth Circuit has done, which is the intermediate appellate court, before you get to the Supreme Court, you have to go district court, appellate court, Supreme Court. By the Fifth Circuit doing this, it tees up what the Supreme Court is actually going to look at. And what they're going to look at is how the FDA, starting in around 2016, loosened the access, loosened the restrictions on this drug so that you could get it by mail, so that you wouldn't have to go to a doctor's office. You could take it further into a pregnancy. All those things that the FDA did to make it easier to get the drug is now what's being challenged. Not the original approval of the drug, but the loosening of restrictions is now what SCOTUS is going to have to take up when the Justice Department appeals this.
Okay, so let's narrow this down. So let's assume the Supreme Court upholds. So does it roll back everything to pre-16? So mifepristone is still it's still available, but you have the hurdles are back.
Yes, and so it takes us back to an older regime. And so the people who challenge us have said, well, how could that be a problem? You know, you operated for several years like that without being able to get it in the mail, so how can you complain? What the drug manufacturers and the Biden administration will tell you is by reverting back in time, you actually change the labeling. And when you change the labeling, that disrupts the entire marketplace and means that the drug will have to be taken off the market for a little bit of time. And so there's a little bit of disagreement on, like, just the regulations here. And so that's why this matters. Even though the practical impact is not going to change anything for anyone today, what this does is tease up a fight later on.
Laura, is the fact that we've gone 7 years with this new FDA regime, if you will, right? And it's sort of, at what point do you say, hey, obviously this didn't present any problems. We don't have any major medical problems here. We don't have any. Does that matter at all?
Well, it would if it was going to trial, right? All of that evidence would come in, all of the safety assessments that the FDA has put forth, that they've filed all this paper about would come in, and then the doctors and the other people who have filed suit would present their evidence to, you know, they have anecdotal evidence of things happening in emergency rooms, right? They'd get to put their evidence, and then eventually a judge or a jury would decide. But again, this is headed straight to the Supreme Court, and they could take it up whenever they want, and I imagine they will take it up for next term, even though they're currently out of session right now.
Wait a minute. The Supreme Court's going to rule out something without ever seeing the basic evidence of the last 7 years?
They're going to see the evidence, but it's going to happen before a trial. And that's part of what the Justice Department has been arguing.
That's a bizarre way to work, isn't it?
Well, it's why they've sort of challenged this thing from the beginning, because remember, it all starts with that federal judge in Texas who decides to block it nationwide without a trial, right? Never had been done before, and that's why the Biden administration was jumping up and down about the decision, but we'll see whether at least 4 justices are willing to take it up. You only need 4 to say yes to taking the case. You need 5 to decide what to do about it.
Yeah, well, I think we know they probably have the 4. Laura Jarrett, boy, thanks for clearing this up and adding to more of the anxiety of where all this is headed. Thank you.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.